Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good day, everyone. Let me introduce myself. My name is Syahrul Fauzul Kabir. I'm going to present my paper submitted to the 5th Social and Humanities Research Symposium, SoRes 2022, which has been funded by LPPM Unisba. This paper is written by me, Mr. Faris Farih Izadi, and Mr. Asep Hakim Zakiran. We are from Faculty of Law, Universitas Islam Bandung. So here are some backgrounds about my research. So there has been an increased investment treaty crisis where the fundamental or the basis for every investment treaty has been critiqued by many scholars because the assumption that investment could bring transfer of knowledge, technology, and capital doesn't match with recent empirical research which prove otherwise. And this has become the ISDS crisis because in investment regime, the foreign investor mostly are able to sue the government directly through the international mechanism, especially the international arbitration, so that the states or the host states are afraid to enact their new public policy due to such threat, especially with regard to the indirect expropriation, which I will explain later. And this become there's a trend to make a reform within investment treaty regime since states realizes that they need a more or greater space to enact the right to regulate within their own jurisdiction. And here are some basic principles of international law of fair investment, where those two concepts, either expropriation or the right to regulate, are based on state sovereignty principle, where the state are basically have a jurisdiction either internally, where they are able to enact law either through legislature, executive, and judicial within their own territory, or even make a treaty externally with other parties. So here are two types of jurisdictions that have, and by making or by enacting international investment treaty, then state have international obligation to fulfill everything regulated within that investment treaty. In case they are not able to fulfill, then they will be regarded as violating such international obligation, and therefore there would be a state responsibility where the state have to make a restitution or reparation. While for the investment treaty, or I call it as investment provision, we could actually differentiate two types of regulation contained in that instrument, namely the procedural rules, which refer to the mechanism or formal mechanism where the foreign investor could sue the government either in national court or even from the international arbitration directly through the investor state dispute settlement mechanism. So it is basically a way for both parties, especially the foreign investor, to gain some assurances. While for the substantive rules, of course, there are so many substantive rules contained within investment treaty, but in this occasion, I only want to explain about two concepts, namely the expropriation, which could take two forms, namely the direct or indirect, and there's also the right to regulate, which could be also interpreted into ways, namely the lato sensu or stricto sensu. Here I'd like to explain about the concept of expropriation. This concept has so many terminology, either it's taking, dispossession, and deprivation, but all of it are the same actually. And these days, many experts are tend to use expropriation to refer to those concepts where this could take two forms within investment treaty, namely the direct expropriation, which usually refer to the nationalization, and also indirect expropriation, which there has actually no definition about it, but if we see it through the subject, then there should be a loss of management or a use of effective control from the foreign investor. Then we could regard it as indirect expropriation, and also from the point of view of object or the investment itself, then there has to be a depreciation of value. And here are 2 points to define whether indirect investment really occur. So many tribunals regard firstly that state measures for investor investment should be at least have three this category. Firstly, the subject, they have to gain some loss of control in the right to use in or enjoy or and dispose of its investment, or from its object. It should be substantial or effective loss or economic value, and from the duration, it must be long-lasting or permanent state measures. Then from these 3 points, then we could interpret that the indirect expropriation occurs. And there's also a second factors, namely the state measure on investor expectation. If there is a legitimate or reasonable expectation, then it must be regarded that the indirect expropriation are occurring. And the third point is that the character of a purpose of state measure. Indirect expropriation is a state sovereignty or jurisdiction as long as it's being done for a public purpose, conducted in a non-discriminatory manner, in accordance with the process of law and with contained with the payment of compensation. Without it, then it will be regarded as unlawful. Here are explanation about the concept of right to regulate. So basically, right to regulate letter sense refers to the sovereignty concept, where the state is able to make investment treaty with other countries, which eventually there would be a international obligations within it. And here is the direct expropriation concept located, because it is one of the international obligation of states. And if they are not able to fulfill it, then there would be a state's responsibility. But there is also this concept called right to regulate stricto sensu, which refer to the one of the substantive rules within investment treaty, which sort of can derogate some international obligation since it is a legal rights. So the definition of the right to regulate concept is the state's right to take measures contrary to its obligation under investment agreements or detrimental to the rights of investor without the obligation to compensate in order to fulfill the public interest. Within investment treaty, there are at least 4 places for the concept of right to regulate, namely preamble, specific exception, general exception, and security exceptions. Here are some examples about the concept of right to regulate within investment treaty. Within preamble in Paper Australia Free Trade Agreement 2018, it is said that recognize the inherent right to regulate and resolve to preserve the flexibility of the parties to set legislative and regulatory practice and so on, which it is not basically a legal rights, although according to Vienna Convention of Law and Treaties, this could be a sort of a context for the international tribunal to interpret uh, the applicable rules within investment treaty. While there's also a specific exception, so here are some concepts which actually refers to the concept of right to regulate. And here are the general exceptions, which are formulated in a more general manner and there's also a security exception. So here are some conclusions that expropriation and right to regulate, stricto sensu, are like two sides of the same coin. This is due to the rules of lawful expropriation, though it is based on state sovereignty, implies state obligation or compensation, whereas unlawful expropriation implies state responsibility through restitution and or reparation. And as for the right to regulate, it doesn't imply both. State measures are considered lawful expropriation if they are conducted by the forces of law in a non-discriminatory manner for the public good and with the payment of compensation. The right to regulate, therefore, may be formulated as lawful expropriation that doesn't require compensation. As an expression of the right to regulate, letter sensu, the state guarantees protection against expropriation while also providing space for the right to regulate stricto sensu through investment agreements. Expropriation is defined as the state measurement right to seize or harm investment in its territory without the consent of the foreign investor. Meanwhile, the right to regulate is the state's right to take measures contrary to its obligation under investment agreement, particularly regarding expropriation, where there is no obligation to compensate. So that's all. Thank you for watching. Wassalamualaikum warahmatullahi wabarakatuh.